Start. The second subpart contemplates that if the petition is not withdrawn in the meantime, the court shall, on being satisfied after hearing the parties and after making inquiries that the averments in the petition are true, pass a decree for divorce stop. In the case of Hitesh Bhatnagar 1, the Supreme Court has held that if the second motion is not made within period of 18 months of the first motion petition, then court is not bound to pass a decree of divorce by mutual consent. Stop. The aforesaid time limit is not for withdrawal of the petition or consent, and can be withdrawn at any time before a decree of divorce is passed. Stop. Para. In the case of Srimati Suresta Devi 2, it has been laid down that on the joint motion of the grant divorce by mutual consent, the court is supposed to make an inquiry, hear and examine both the parties to ascertain that the averments made in the divorce petition are true and that the consent of the parties has not been obtained by force, fraud or undue influence. Para. Section 23 within bracket 1 of the Hindu Marriage Act, 1955 also casts an upon the courts in the matter of divorce by mutual consent to satisfy itself that the consent has not been obtained by force, fraud or undue influence. Stop. Thus, the court is obliged to make requisite inquiry in the matter before proceeding to pass a decree of divorce by mutual consent. Para. It means that for a decree of divorce by mutual consent, joint petition is mandatory and that the second motion has to be made by the parties after 6 months but before expiry of 18 months of the first motion petition and that the parties are free to withdraw the petition any time before the passing of the decree. Stop. The decree has to be passed after making due inquiry as to the genuineness and bona fide of the parties to the petition. Stop.